Lord, item 260, Lord. This matter, I have made my submissions in April, and it is pending for the reply by the vigilance. This small matter where it's something like 2 plus 2, the learned special judge came to the answer of 5. If it is 4, there is no case. Your Lordship has heard it in April, my submissions. Can it be taken up on Monday, my Lord?
No,
at 3
it's
p.m. or
a
3:30
vigilance.
Vigilance.
Monday, I think, you election petition 5th, na? Okay. Monday one next week, or 25th. So let it come on 26th then.
Yeah, 26th I will be absent that week.
Because once
At
it comes,
3:30 or
once it comes at Monday, Tuesday, it can come in the supplementary list. That's why I'm telling you. So that
Lord, your Lordship has adjourned it for that, and it was not listed. Earlier also it was adjourned to a Tuesday, it was not listed.
Okay. All right. 25th 3:30 kar diyon kala. Okay. Yeah.
I didn't mention that. Tired of bed up this.
Please give it. It will come.
Let this criminal record listed on 15 Lordship is subject related to written up procedure article, Lordship.
Please give it.
I may be pardoned to make a mention. Your Lordship, item 205 of the weekly list, Your Lordship. We have an application, pending application for bail, Your Lordship. A report was called for from the local police. That has already come, Your Lordship. So item 205 may be taken up at the end of the board, Your
What
Lordship.
report was called for?
Your Lordship, the appellants had been released on bail once, Your Lordship. So Your Lordship had been pleased to call for a report from the local police whether they had violated any conditions during that pendency or during that interim bail application, Your Lordship.
All right, we'll see that. It's come.
Much obliged.
Supplementary list item number 1.
No, it's extension of time. Jati time to extend further. No? Yes, next.
Item 2.
Same. Extend the time and intimate the consent court. Yes.
3.
Okay, it is to be corrected. Give me red pen. Today is 21st, no? Right. 21/9/2023. Take down that peruse the office note wherein it is mentioned that in order number 2, the date of the order has been inadvertently typed as inverted comma with 11/1/2021 instead of 11/1/2022. Stop. The later one of the year 2021 is scored out by me in braiding in open court and corrected as 2. Yes. Next.
Item 4.
Same extension of time. Intimate the consent court. Yes. Attorney of the Moroccan.
5.
What is the CRLA for?
Appeal under section 14 of SCSTR.
What's your bail matter?
Miller.
So, I means copy has been served on you?
Yes, my Lord. Yes.
Okay.
He is appearing for the informant. I have solved the copy as per your Lordship's direction.
One more thing, my Lord. The last occasion I have said it is my mistake. That examination has not yet been started. In the meantime, 11 witnesses has already been examined.
What is the offense here?
Offense is, my Lord, initially was registered under section 302, 394, 324, 326, 307 and 506. Subsequently
3 SC/ST Act was added.
added in charge sheet.
No, your rejection order is dated 29/4/2022.
Again.
But he says that in the meantime, more than 12 witnesses have been examined.
11 witnesses.
11 witnesses have been examined. So have you got those deposition copies with you?
No, I don't have.
Then obtain it and supply to the State Council and to the court also.
I will do. I will do.
That's why as mentioned that let status report we call for.
Yes.
That's why on Monday I submitted that let it status code we call for. But they told that no witness has
No,
been
no, it
examined.
was my mistake.
My learned senior said.
Yes, yes. It was
Now-
my mistake that
Okay. Now you have here the certain. Listen, the learned counsel for the informant submitted that he has received the copy of the appeal memo along with the annexures from the learned counsel for the appellant. The rejection order is dated 29/4/2022. Stop. Learned counsel for the informant submitted that he has received instruction that in the meantime, trial has commenced and 11 witnesses have been examined. Stop. The learned counsel for the appellant submitted that he may be given some time to ascertain about the correct state of affairs, and if witnesses are examined, he will produce the certified copy of all the witnesses examined so far in the trial court by the next date, giving copies to the learned counsel for the state. Kebe rakhibi kuhantu?
Can be taken up on 12th minute.
List this matter on 12th of 12th night 12th is a hearing day kouchanti apono. Ab somar
11th.
mangalar kuhantu.
10th kar do.
Ha
10th. 10th minute.
10th. 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 10/2022. Deposition copy to be supplied. Yes.
Great.
Item 6.
Last occasion, I am directed to solve the copy. I have solved the copy. This case, a co-accused, principal accused already risen bail.
Wait. You are appearing for the informant. Mr. Das, you have received the case diary. Okay. Is it your first bail application or earlier rejected?
Yeah, fast bail.
And in CRLA, he double 8/23 my lord.
Astile aguru?
Out a case, out co-accused my lord. Has granted bail.
This is the copy, my lord. This-
CRLA 282/2023. So what is your date of custody?
Date of custody, my lord. 7/11/22. 2022. हाँ.
देखिए कौन
7/11/2022.
फिरोज परिडा
Hirot Parada, Kunni Parada. Kunni Parada, the principal accused. Because conspiracy by the Kunni Parada.
wait this is Manoj Gochayat was found missing on 13/10/2022. Missing report was lodged on 15/10. FIR was lodged on 2/1/2/11/2022. No eyewitness, case based on circumstantial evidence. No clinching material available on record, and Kunni has been released on bail, so on so. State, while not disputing that the case is based on circumstantial evidence, submitted that at the instance of the appellant means Kirot Korida, recorded under section 27 of the Evidence Act, key of the motorcycle of the deceased, Manoj Gochayat, was recovered. informant oppose the prayer for bail and place the statement of R.I. Vishwaranjan Hembram, who is a witness to the leading to discovery. So and so, so and so. Yes, Mr. Das, same putting. What do you say?
No, my lord, he is the principal accused, my lord. Kindly see this, his statement also.
Whose
He has-
statement?
My lord, this present appellant, he has confessed that he has committed the murder. I am reading out the relevant portion, my
What?
lord.
Before whom he has given this statement?
And before the police and also in presence of the official witnesses, two
So-
official
So
witnesses.
what? How far? Why is it
My lord,
admissible?
My lord, the circumstances very strong, my lord.
What other circumstances?
Other
Leave that.
circumstances, my lord.
What is not admissible? Don't rely on that.
My lord,
It's
my
a
lord, other-
confessional statement before by the appellant before police. You want to read it out?
My lord, the other circumstance, my lord.
Yeah.
He has missing since 13 minutes.
Mm.
On 15, my lord, the first affair was lost, missing affair was lost before the Nikirai police, my lord. And thereafter, my lords, the motorcycle which has been, my lord,
That motorcycle key was seized from a particular accused. He has already
My-
been released on bail.
my lord, both has taken away the motorcycle and this chappal, my lords, at his instance. ये आगे से चप्पल पिंदीगिरी मोटरसाइकिल
I'm
बसी
telling
जाइए
you what is the distinction or difference between this co-accused Khirod and this present petitioner. State counsel has said that similar footing. How do you say that it is different?
Well, different minutes, but all the witness and he has his co-villager also stated that he has stated for me, and other friends of the deceased Millard, they have stated they have seen this Millard, the deceased. He has gone last in, and the Millard's 27 is there.
All right.
And
Your client is there here.
no Millards.
He's watching.
Well, man, he's no Millard. Millard, he is
He's
the
not
sole.
he's not watching.
No,
it.
no, no. Well,
You
he's
have-
the sole
You have not
person.
given the link of live streaming to him. No, all right, please take down. Yes. So এটাকু add कर देवे এই জায়গারে ক্ষীরোদ পরেটা জায়গা এটাকু add कर দিয়ে allow कर देवे. Yes, next. Problem.
Item 7.
Yes, Mr.
This is a case matter shall come for fresh admission. The petitioner. is
Which
a-
order you are challenging, Mr. Rao?
I am challenging the order dated 30/11/22, Annexure 3 at page 19. First will come to page 21.
Okay, your discharge petition was rejected.
Reject.
But then the date was fixed to 15/12/2022
That is fixed
for
to
framing
today.
of.
That is fixed to today. Each time I have been taking.
No, for what purpose?
For framing of charges.
No, how can I know unless you produce the certified copy? Because the date was fixed to 15/12/2022
Yes,
and almost more than 10 months have already passed.
yes, sir.
So unless you produce the order sheet of the trial court to show that yes, till date charge has not been framed, otherwise you have to amend your FRAIR if the charge has been framed in the meantime. Have you got the certified copy from 15/12/2022 onwards?
No, not
Then
onwards.
please bring it. I am keeping it. If you want it, I can be taken up next week also.
No, my lord, the case is posted to today. for
It's all right.
appearance.
Case must have been posted after 15/12/2022, which was posted.
Yes.
Then it must have been posted for on number of occasion for framing of charge. If you are saying so, so please bring it that till today also it is not. Unless you bring it, what is your instruction, Mr.
About framing of charge notes.
No. Yes, it's about framing of charge. Mr. Rao said it is also the date is posted to in the trial court and for the framing of charge. So what is your instruction?
I have to verify that thing, but other materials have brought all the statements of
Ho-
the.
I can hear the matter. Only one hurdle is that I am to sure that charge has not been framed. It can be taken up next week also. Just
Yes,
obtain the instruction.
If you
Mr. Rao, let it come on Tuesday. You just obtain that. Let the state council.
I got the certified copy. Somehow it is misplaced from the file. Can it be after recess so that I can produce that?
How can you produce unless you apply
there.
for the same.
Certificate copy has been sent to me, but in the file it is missing some
Okay, then it's all right. No, about today.
2 days. That the case is posted to today.
No, I do not know. Suppose in the first hour the charge is framed, so that is creating difficulty. Better let it be on Tuesday. That means on 26th you obtain, and you also lekon the rejection, the order under challenge in this revision petition is dated 30/11/2022, passed by the London Special Judge Vigilance Barampur in GR case number 6 of 2016 bracket V, in which after rejecting the petition for discharge filed by the petition under section 239 CRPC, date was fixed to 15/12/2022 for framing of charge. Mr. Rahul and senior advocate submits that since 15/12/2022, the charge has not been framed, and he has received instruction that even today in the trial court, the date is fixed for framing of the charge. London counsel for the standing counsel for the vigilance department, Mr. Sangram Das, also submits that he may be given some time to obtain instruction in that respect, list this matter in the week on 26 September 2023. The Land Council for the petition shall produce the certified copy of the order sheet from 15/12/2022 onwards. Yes. Now I come to the weekly list. Who ଯାଇଥିଲା? State continue କରିଦିଅନ୍ତୁ 100 ପର୍ଯ୍ୟନ୍ତ, ତାପରେ ଆପଣ ଇଏ କରିବେ.
Weekly list item number 67.
67 Where is it's all right. Where is Mr. Bhuiya or Mr. Patra? Pass over. Then next.
68.
এটা কোন কনভিকশন কেতে কেতে ବର୍ଷ ହେଇଥିଲା?
7 years in total.
Item 70.
I may please your lordship. The appellant is challenging the order for conviction dated 24/4/23 by learned Assistant Session Judge Bhanjanagar.
Have you supplied deposition copy?
Yes, yes. My lord, he was convicted.
Come
under
to the operative part of the judgment.
page 15 of the judgment.
1-5.
My lord.
Internal page or running page?
Internal judgment.
Internal
Judgment.
page.
Judgment.
Judgment page number 15. Okay. It is 320.
Highest punishment is 10 years.
Who offense fine?
Three explosive substances.
You were on bail or
He was on bail during.
what is the name of the petitioner? Adibandhu.
Hadubandhu Chenna.
Okay, as it appears, you were first taken into custody, page number 2, on 10/2/2015.
My lord.
Then you are released on 22/3/2016.
My lord.
Then again on 5/3/23,
Took it left.
you are taken into custody, and since then you are in, right? So the main offense is that explosive substance.
Explosive.
So what you did, what is the allegation against you?
Exploded a bomb.
Exploded a bomb.
And simply injured.
Who is the doctor?
PW9.
Where that evidence of that doctor has been discussed in the impugned judgment?
Page 10, man.
10. Full line.
Page 9. Page 9. PW9 had opened that the injuries were simple in nature.
Room. PW9 medical officer
My lord.
of CHC, Uguda, who had examined PW2 on 16/3/2012 at 10:30 a.m. on police requisition, found multiple abrasions on his leg with different dimensions. Has opined that injuries were simple in nature and might be caused by blunt weapon, and the age of injuries were 24 hours at the time of examination. Okay. आर कौन सब रही क्रिमिनल एंटीसीडेंट रिंग्स ये बम पकेला वाला ना थिबो तार आउ कौन देखि दियो
The informant was the Sarpanch, my lord.
yes
Informant PW1 is was the Sarpanch at that time.
हां कौन हला
Out of political rivalry.
हां दे आउ के जन लोक बम पकेजन सेटा टी आनो तुसे लेखों the London Council for the State submitted that he has received the copy of deposition of the witnesses from the London Council for the appellant. And since it is a case where the allegation against the evidence has come on record against the petitioner that he threw bomb. Are the villagers which exploded and kiye injury sustained kala?
PW1, 2, 3.
And number of persons have sustained injuries. You may be given some time to obtain instruction about the criminal antecedent, if any, against the petitioner. Buguda Thana, from the inspector in charge of Buguda Police Station. Please this matter in the week commencing from Gote Saptah chhad diyon. 3 तारीख रखी दियो 3rd October 2023. Free copy of the order be handed over to the London Council for the state. 3 10/2023 CA to be obtained. Yes.
Miller. Item 67, Miller. Petitioner counsel is present here. Taken up.
Okay. 67 টা দিয়ে বার করুন। The appellant name is Suresh Chandra Padhi.
My lord.
So, since when you are in custody, you said?
24/2/2014
No, you come to the page number 3 of the impugned judgment.
My lord.
in both
It is
the
mentioned that that Chandra Kant Bhargav Gole, he was taken into custody on 22/2014. But so far as your case is concerned, it is not mentioned. You mean to say 2014 you are in custody? So let us come to LCR as trial court record. Trial court record. Final form to the come. Suresh Chandra Padhi. हाँ এটা হলো 20/2/2015. So you have never been released on bail.
My lord.
Custody.
for 10 years.
Wait, just wait. Mr. Patro,
Miller.
as it appears, this appellant
Miller.
was taken on remand in this case on 22/2014.
Miller.
Order sheet reveals that he has never been released on bail.
Miller.
তো 20/2/2014 ମାନେ ବର୍ତ୍ତମାନ ପର୍ଯ୍ୟନ୍ତ ସିଏ ଯଦି କଷ୍ଟଡିରେ ରହୁଛି ତାହେଲେ 9 ବର୍ଷ ଆଉ ପାଖାପାଖି 7 ମାସ ହେଇଯାଉଛି. So what is the sentence imposed by the learned trial court? It is judgment question.
7-2 Miller. Convict on 6 OPID Act, he has sentenced for 10 years Miller and 50,000 fine.
That is the main punishment or
Yes,
any other?
that is the main 10 years.
7 years ହେଲା 420 ରେ 3 years ହଉଛି 406, 5 years ହଉଛି 120p, 2 years ହେଲା 45, right years money circulation, okay, 10 years and fine of rupees 50,000, 6 OPID Act, so and so, concurrently. So 10 years ରୁ ଜଣ 9 ବର୍ଷ 7 ମାସ ରହିଗଲେଣି. So let him go on bail.
Miller.
Heard the learned counsel for the petitioner and counsel for the state. Considering the submission made by the learned counsel for the petitioner that the petitioner has been sentenced to 10 years imprisonment by the London Trial Court, out of which he has already undergone 9 years and 7 months of sentence by now. And there is no chance of early hearing of the appeal in the near future. And after hearing the London Special Counsel for the State of Orissa in OPID Act matter, Mr. Patro, I'm inclined to release the petitioner on bail, stay realization of fine. Yes. Yeah. 68, yes. 68.
The respondent number 2210, they have been charged under section 147, 148, 323, 324, 326, 294, 336, 506, 307, and 149 IPC and the Honorable Learned Court after trial has acquitted them on 3 grounds. First, he has said the enmity. Second, he has said the IO has not been examined.
No, the main offense is 307.
My lord, 307 and 326 also.
Okay.
3 fingers has been disrupted. And he has acquitted, the Learned Court has acquitted on the ground of enmity. Second ground, he has taken that the IO has not been examined. And third, one of the injured has not been examined by the prosecution. With this, my lord, technically, this, my lord, he has acquitted the, although the prosecution witnesses has fully corroborated, my lord, regarding the assault, the specific role attributed to these respondents, my lord, whoever the accused persons, but still then the Learned Court has acquitted. IO, examination of IO is not on my control because I being an informant, my lord, I have deposed to my extent, my lord, which is has occurred to me, I have deposed before the concerned court. And so far the other examination.
No, he has discussed the, as I find, the evidence of each witness. Now come to the evidence of the doctor. Page number 16 of the judgment. Let us see that what sort of injuries the injured persons have sustained. So one injured is Chaitanya Kumar Parida, page 16. His PW1, that is one incised wound, and then two dita injury roichi. Both the injuries are simple in nature, right? Then gote achi arm re, ଆଉ gote achi left thigh re. Then PW6 ପୁଣି examine kala Arjuna Paridaku. Incised wound, then another on the incised wound, another on the incised wound. Okay. 1, 3, and 4 are grievous in nature, and injury number 2 is simple. Acha. Refer to SC Medical College for treatment. So, which is that portion of the judgment where the case has been, prosecution case has been disbelieved?
Mainly.
Lakshmi, kindly come to page 56, para 7 of the
Para 7.
As per the evidence of PW 128, it appears that on the relevant date of incident, that is on the dated 30/4/2005 at about 7 a.m. to 7:10 a.m., accused persons has assaulted PW1 Arjuna Parida, PW2 and PW8. Arjuna Parida was not examined. One of the person who has been assaulted by prosecution due to his death. Though PW1 had stated that accused persons came to the spot being armed with bhujali and thenga and had assaulted him, and Arjuna Parida, for which both of them had a sustained bleeding injury, but he had not stated anything that on the same day of the incident, accused persons have assaulted PW2 and 8. Also, nor FIR by Exhibit 7. That on the date of the incident, being assaulted by the accused persons. That is not stated either in the FIR nor in their depositions. PW2 and 8, nor these two witnesses had lodged any report against the present accused persons regarding assault upon them by these accused persons, and for the first time they had deposed before this court that they are assaulted by the accused persons on the relevant date and time of the incident. PW1 in his cross answer had stated that the house of Pratap, Parshuram, Dani, Vrindavan, Uttama, and Dukhavandu are situated near his house, as well as the house of his brother, namely Arjuna Parida. But none of them these persons were cited as CS witnesses, nor they were examined by prosecution.
Classes of the prosecution.
Further, from cross-section of PW1, it appears that the time of incident, though his younger brother and daughter-in-law, late Arjuna, were present at, and they also came to the spot after assault upon him by accused persons. But IO during course of investigation has not taken any steps to examine them as CS witness, nor had recorded their statement on the section 161 CRPC
To support and strengthen the case of prosecution, admittedly informant PW10 was not present at the spot at the time of occurrence, and he had clearly stated in his evidence that at the time of incident he was present at his village Telangpada, and he heard about the incident from one Kolkara Borad. And on the
No, Mr. Mishra, two things I just want to say that one thing is that as you just go through that injury reports which has been proved by the doctor, it appears that at least one of the injured has sustained 3 grievous injury. That is that name perhaps is Arjun Parida.
He is the person who has not been examined.
Because he died. Okay.
1 year after the occurrence.
Right. And the trial court has mentioned that this person's house was nearby. This man's presence was there as report, but they have not been examined. But what about those injured persons? Once they have injured means their presence cannot be doubted at the spot. And when their evidence has not been second, merely because some of more witness have not been examined in the vicinity, can that be a ground to disbelieve the injured statement? Unless the injured statement is discarded merely because it is not the quantity, it is the quality of evidence that counts. 134 of the Evidence Act says.
Court has observed, my lord,
Yeah.
that on the date of incident that occurrence took place and they were assaulted on the date of incident, that is not mentioned in the either in the body of FIR nor in the
No,
deposition.
no,
That is there.
just let us see. Then FIR copy nahi ki apna pakhre? Dele. FIR, who is the informant in the case?
Informant is PW.
Informant na hochi Biranchi Kumar Parida. He is PW? Judgment to dekhundu pachhe.
Biranchi Parida. Biranchi Parida PW10.
PW10. ଆମେ ଶ୍ରୀ ବିରଞ୍ଚି ପରିଡ଼ା 30/4/2005
He was not present at the spot. That is
ଘଟଣା ହେଇଥିଲା ମଧ୍ୟ ସେଇ ଦିନ 30/4/2005 ସକାଳ 7ଟାରେ ମୋର ବାପା ଅର୍ଜୁନ ପରିଡ଼ା ଦାଦା ଚୈତନ୍ୟ ପରିଡ଼ା ଆମ ଘର ବାରଣ୍ଡାରେ ବସିଥିବା ସମୟରେ ଆମ ଗ୍ରାମର ସୁଆଂଶୁ ପୂର୍ବ ପ୍ରସ୍ତୁତି ଅନୁସାରେ ହାତରେ ନାନାଦି ହାତ ହତିଆର ଯଥା ସୁଆଂଶୁ ଧରି ଅଶ୍ଳୀଳ ଭାଷାରେ ସୁଆଂଶୁ କହି ଆମ ଘର ଆଡକୁ ମାଡି ଆସିଲେ। ପ୍ରଥମେ ପବିତ୍ର ରାଉତ ମୋ ବାପାଙ୍କର ଗୋଡ ଆଣ୍ଠୁ ଗୋଟିଏ ଭୁଜାଲିରେ ହାଣିଦେଲା, ସେ ତଳେ ପଡିଗଲେ। ସୁଆଂଶୁ ମଧ୍ୟ ଭୁଜାଲିରେ ଅନ୍ୟ ଗୋଡ ସୁଆଂଶୁକୁ ହାଣିଲେ। ଗୋଡ ଗୋଛିରୁ ପ୍ରବଳ ରକ୍ତସ୍ରାବ ହେଲା। ମୋ ବାପାଙ୍କର ଶରୀର ଦୁର୍ବଳ ହୋଇଗଲା, ସେ ତଳେ ପଡିଗଲେ। ପାଣି କାଣି ବୋଲି ଚିତ୍କାର କଲେ। ଏହି ସମୟରେ ପବିତ୍ର ରାଉତ ମୋର ବାପାଙ୍କର ବେକକୁ ଲକ୍ଷ୍ୟ କରି ଚୋଟ ମାରିବାରୁ ସେ ହାତ ଦେଖାଇ ଦେଲେ। ତାଙ୍କର ହାତର 4ଟି ଆଙ୍ଗୁଠି କଟି ଯାଇଛି। ଅନ୍ୟମାନେ ସେହି ସମୟରେ ମୋର ବାପାଙ୍କୁ ନିର୍ମମ ଭାବରେ ନାଇଁ କଣ କହୁଛନ୍ତି, କିଏ କୋଉଠି ଲେଖିଲେ ନାଇଁ? କ୍ଲିୟରଲି କୁହାଯାଇଛି।
It is observed that he was not present at the time of
Who is not present?
the PW10 man.
PW?
Informant PW10 was not present at the spot at the time of occurrence. And he had clearly stated in his evidence that at the time of incident he was present at village Telangana.
It's all right. Suppose he was not,
evidential
Mr. Mishra, suppose he was not present. He came to the spot after hearing about the incident. So he is the informant. He set the law into motion. But what he has stated that after hearing from his family members who has assaulted whom, that part has been mentioned. And those injured persons were examined during trial. and they said that we have been assaulted by this person, and which is corroborated by the medical evidence. 3 grievous injuries are there. So how do you say that merely because the informant is not an eyewitness? He has fairly stated that I am not an eyewitness.
Page 30, my lord. Page 30 in the deposition.
Yes.
Exactly what my lord is proposing, that is there. Para 2, my lord. Page 30, para 2.
Yeah.
The incident took place near my house, situated on that relevant date and time of incident. I was not present at village. I heard the accused, namely such and such person, assaulted, and thereafter I immediately rushed to the spot. And my lord came to know, lost the affair.
Obviously, so that cannot be a ground. It's not that the informant should be an eyewitness to the occurrence. Anybody can set the law into motion. So, as I find, the main reason is that the informant is not an eyewitness. The second is that the other persons who were present at the spot in the vicinity at the time of occurrence, whose houses are there, they have not been examined. If that would have been a case, then in every case the prosecution will examine not less than 40-50 persons.
No,
Suppose
besides that, my lord, PW2 and PW8 has not stated that on the same day, the date of occurrence which has been stated, on the same day they were being assaulted by the accused person. That is also not there.
PW2.
PW2 and 8. The injured.
Come to the evidence of PW2.
11, page 11, my lord. Page 11.
Mr. Chan, please read it out.
My lord, I know all the eight accused persons, so also the informant of this case. I know the injured. The occurrence took place on 30/4/2005 at about 7 a.m. At that time, I was at my house. In the meantime, accused Babuli came and abused me in obscene language by saying slang language. When I along with Suro Maji protested, then accused Babuli and Ointa pelted stones causing bleeding injury on my head. Witness shows his scar mark. The stone hit on the leg of Suromaji. Then we shifted to medical by Ganeshwar and Lakshman Maji. Subsequently, I heard that the accused persons assaulted to the injured Chitta and Arjuna. These are the metals.
So he's a witness to the part of the occurrence.
Right.
So where from you got that he has not stated about the date on the occurrence took place on 30/4/2005, and he has stated what has happened on that day till a particular period, because thereafter he removed the then we shifted
Hospital
to the hospital by Ganeshwar and so on. So subsequently I heard that the accused persons assaulted to the injured Chaitanya and Arjuna. That means what he said, that the assault on these two injured, or Chaitanya and Arjuna, that has not taken place in his presence, but which he heard. Who is the other one you say?
PW8.
PW8.
Is 26.
Yes, PW8 পড়ুন।
Sura. I know all the accused persons, so also the other two absentee accused persons. I know the informant. The occurrence took place on 30/4/2005 at about 7 to 7:10 a.m. While I was sitting on my veranda, I found Babuli abused by saying slang language. When Dilip and myself protested, then accused Babuli and Anjan pelted stones to us, causing bleeding injury on my left leg, and Dilip sustained bleeding injury on his head. The villagers shifted us to Sachin hospital. After half an hour, I found Chaitanya Pada and Arjun Pada with bleeding injury and in unconscious state, admitted to hospital. I heard that accused persons assaulted them.
So he was not present. He has not seen the.
He is the Kini.
PW8.
While I was sitting on my veranda, I found Babuli abused by saying so and so. When Dilip and myself protested, accused so and so pelted stones to us, causing bleeding injury on such and such parts of the body and on the head. Villagers shifted us so and so. So, se porjonto at least to iye ithla na. तो जेतिकी इंजुरी जी जहाँ कहूची से समस्ते भी कहउछंती से जो दीटा विटनेस जे एतिकी इंसिडेंट आमे देखीचु तापरे आमे को हॉस्पिटल नेला परे आमे सुनिलु जे एमानो को आमे आम परे असॉल्ट हेची आई फाउंड चैतन्य परिडा एंड अर्जुनो परिडा with bleeding injury and in unconscious state so and so. So there are eyewitnesses to the occurrence apart from the injured persons.
Middle one.
So किछि जो माने obviously प्रथमरु माड़ खाइकिनी हॉस्पिटल को शिफ्ट ही जाइछंती से माने गला परे जो इंसिडेंट गुडा हेची से माने कर डायरेक्ट नॉलेज रे नाही से माने कहउछन हम सुनिलु ता परे बट ता पर इंसिडेंट गुडा को अन्य इंजुर्ड माने कहउछंती and that is corroborated by medical evidence also. This Biranchi Parida is the informant, na?
Biranchi, yeah, Biranchi Pirutan informant.
Yes, Pirutan.
All right. I'd admit, call for the trial court record. Issue bailable warrant of arrest under section 390 CRPC against the respondents number 2 to 10. On their appearance before the London trial court, that is Assistant Session Judge Anandapur, in ST case number 39/259 of 2005, they shall be released on bail. Yes, next.
Copy.
And here to file the requisites by
Monday.
By Monday kar diyon for issuance of notice to respondent number 2 TO2 से जो last respondent এটা নিয়ে যান তো FIR টা দিয়ে দিন
ये
जो येटा लिखिए अपन this appeal is under section 372 CRPC filed by the informant challenging this one so land council and the land state can appeal the judgment and the deposition copy then kariye admit issue so that's all लिखिए yes
73 my lord, I have filed my objection since 29/8. It is not reflected in the cause list. 29/8 I have served the copy
20.
on the appellate on 30/8.
The stay of conviction application.
Let it come
Have
after.
you received the copy of objection?
Yes, yes.
Let it come after puja vacation, my lord.
What is the conviction?
Trap case.
Trap. The decoy, etc. They have supported the prosecution case.
Decoy has not supported.
Okay. What about?
And the trial court has relied upon the FIR, the 164 statement of the complainant, preparation report, detection report.
What about the overhearing witness?
Overhearing, Millard, he has said, what he has said is not contrary to the defense of the appellant.
Okay.
The complainant said that the accused said, it does not say that the accused demanded any bribe. Accused said that you have taken a loan from a neighbor of mine.
Complainant or overhearing witness?
Complainant.
Okay.
That you have taken a loan from a neighbor of mine, you please return that loan amount. And that loan amount he returned. A complainant, a overhearing says that when the complainant went, accused said, "Kona anicho." That's the only thing. And this is in chief. That Kona anicho, it may be that return of the loan amount. And in cross-examination, the overhearing says that on being signaled by the complainant that he had paid the money, he gave the signal. So that again rules out that he has seen anything or heard anything.
Your 313 statement is that about that complainant that tallies with him that you have received that money. You admit that you have received the money.
That
I do not know whether the IT trial court record has accused statement account. No, no such specific plea has been taken.
No.
You said he has supported the defense plea. I said that what is your plea? That's why. Who is the that decoy?
decoy is PW6. Decoy para 3 Miller. Then we proceeded to the office. No, I think it's para 1, para 2.
No, para 1 he has stated when I met the accused, he asked me about the loan of rupees 4,000
Yes.
given by one of the neighbors to me, and at that time accused assured the said amount of his neighbor would be returned to him. I assured him after passing up my bill I would pay the amount. However, okay, then para 3 re kon kaile? Patua Babu stood near the door and I entered into this one. So I told him that I would give the money.
To the madam had given me, I then gave the loan amount to the
And he was declared hostile. Okay, after that.
Para 6 may kindly be referred. Para 6. He does not know the name and address of the person, borrower, who had taken 4,000 from the accused.
Para?
Para 6, fifth line, sixth line.
Yeah.
I cannot say the name and address of the said person, borrower, who had taken rupees 4,000 from the accused. I have not disclosed at the time of preparation before independent official witnesses Janna Babu and Kotua Babu that the accused had to get back rupees 4,000 from his borrower through me. I had brought the tainted money by borrowing from others, which were seized under the detection. If the lady had given 4,000 to refund it to the accused, why he borrowed the amount of rupees 1,000 and brought to the vigilance office? And he does not know the name of the borrower when he is the neighbor.
So what you have asked him?
It is strange.
No, you have asked him something else. He said that he had borrowed from a neighbor of the accused. The complainant had borrowed from a neighbor of the accused. The question is, as if accused had
complainant borrowed, not complainant borrowed. Accused had borrowed.
I cannot say the name and address of said person borrower who had taken 4,000 from accused. That is something else.
So all these facts will be decided at the time of final hearing.
Paragraph number 15 of that decoy's evidence the last 4 lines. When I was coming to my father and discussing about the work, said woman came to know my acquaintance with the accused, and so he had given rupees 4,000 to give the accused, which she had taken from the accused as loan.
Para 17 में kindly be refer.
Yeah.
Cross-examination.
I was aggrieved by the accused as he committed delay in taking the measurement of my work. As the accused made delay in measurement, and I make delay in handing over rupees 4,000 given by the woman neighbor of my father. And when the accused demanded, thus being aggrieved, I made a report before the vigilance.
When the accused demanded, thus being aggrieved, I made report before the vigilance. In the cross-examination, he says so.
ନାଇଁ ନାଇଁ ସିଏ ତା ମାନେ କହିବା କଥା ଯେ ଓମ୍ୟାନ ନେବର ଟୁ ସେ 4,000 ଟଙ୍କା ଅଲରେଡି ପାଇ ସାରିଥିଲା, କିନ୍ତୁ ଆକ୍ୟୁଜ କହିଥିଲା ଯେ ତା କାମ ଶୀଘ୍ର କରେଇ ଦବ ବୋଲି ମେଜରମେଣ୍ଟ। ତେଣୁ ଯେହେତୁ ସେ ମେଜରମେଣ୍ଟ ଡିଲେ କଲା, ତା ପାଖରେ 4,000 ଟଙ୍କା ଲୋନ ଆମାଉଣ୍ଟ ସେ ସ୍ତ୍ରୀ ଲୋକଟା ଯୋଉ ଦେଇଥିଲା ପଡୋଶୀ ଥିବା ସତ୍ତ୍ୱେ ମଧ୍ୟ ସିଏ ଦଉନଥିଲା ଏବଂ ୟାକୁ ରିପୋର୍ଟ କଲା ଭିଜିଲାନ୍ସ କୁ।
ସିଏ ତ ପଡୋଶୀର ନାଁ ଜାଣିନି, ତାପରେ ସେ ନିଜେ କହୁଛି ମୁଁ ଧାର କରିକି ଆଣିଛି 4,000 ଟଙ୍କା ଭିଜିଲାନ୍ସ ଅଫିସ କୁ। ପାରାଗ୍ରାଫ 7 ଯୋଉଟା ପଢିଲି ମୁଁ ପାରାଗ୍ରାଫ 6 ରେ, I had brought the tainted money by borrowing from others. ଯଦି 4,000 ଟଙ୍କା ଏ ଟଙ୍କା ଆଣିବାର କଣ ଜଷ୍ଟିଫିକେସନ ଥିଲା, which were seized after the detection.
It's all right, Mr. Das, when your witness is giving this type of statement, prevaricating statement from time to time, so can it be acted upon? Question is that you are to prove your case. So whether we are concerned with it that 4,000 rupees is a bribe money or it's a tainted money which was demanded by the accused to do certain work. But when your evidence gives this type of statement that at one point of time he said that this was the money of the given by my neighbor, so which I am supposed to give to the accused because that neighbor had taken as loan from the accused, then again he says something else. So
your lordship kindly refer to PW4 overhearing witness. The complainant has narrated before them that the accused was demanding for submission of bill of the dog well, first paragraph, PW4.
No, when the complainant is not himself saying about that, so merely because somebody else says that he has disclosed before others.
Other witnesses are there, and your lordship is very much aware about the honorable 5-judge bench decision. Even if complainant declared hostile.
What the overhearing witness has stated?
Paragraph 1, 5th line.
In this case, my lord, the
complainant narrated before us that your lordship got it, PW4.
Yes. PW4 I am holding.
4th line. The complainant narrated before us that the accused, being the assistant agricultural engineer, has advanced demand of illegal gratification of rupees 5,000 towards submission of bill of the dog well of complainant for the purpose of its recommendation for getting of his subsidy, and that the said demand was subsequently reduced to rupees 4,000 by the accused. Saying so, the complainant produced 8 numbers of 500 rupee demonstration GC notes before us. The serial numbers thereof were noted down by the Abhimanyu Jena, PW1. Reaction of chemical mixture of one chemical powder with chemical solution conveyed to us on demonstration by one constable in the manner.
Mr. Das, से hearsay evidence गुड़ाक आपण पढुचंती जणे जी जार प्रकृत रे विषय रे नॉलेज अछि सी जदी कहि थांता जे हां एई जिंस हेइची एवं ए जिंस को मु PW4 को कहिची ताहले एटा एडमिसिबल हबो जदी जो लोक को डिमांड हेइची बा से लोक निजे ही कहूनी जे अक्यूज डिमांड करथिला बोली एई काम पाई तो जहा पाखे रे कहिची सी जदी भी कहिला जे मते decoy e bisare कहला, how it will be admissible? It's a hearsay hit by section 60 of the Evidence Act.
Will it be decided at this time of
No,
this?
that's a different matter. That's a different matter. You are harping that.
So, your lordship have already held that honorable five judge decision that all this materials will be.
अरे से ये ओवरहियरिंग विटनेस ऑफिस विषय कौन कहला ऑफिस राशि कौन देखिला बा कौन सुनिला
When accompanied paragraph 2
रे हाँ कौन पढ़ंतु
after of preparation, the trap party members, including the complainant, myself, and Jenna Babu, proceeded to agricultural office Banki in a four-wheeler vehicle around 9 a.m. and arrived there around 11 a.m. The DSP and Jenna Babu stayed near Banki Bazaar. Two of the constables remained at a petrol pump located in front of the office of the accused, whereas I accompanied the complainant inside the office of the accused. I was following the complainant at little distance up to the office of the accused. The complainant entering inside the office of the accused sat on a chair placed in front of the accused table, and the accused was sitting on his office table. I stood at the veranda of the office at a visible distance. The place where I was standing was clearly visible from the place where the complainant and the accused were sitting. I heard the asking of accused, "Kon anicho?" to the complainant. The complainant, bringing out the tented notes from his wearing shirt pocket, gave the amount to the accused, who received the same.
ମିଷ୍ଟର ଦାସ ପଜ ଦିଅନ୍ତୁ ଯଦି ସିଏ ତାକୁ ଆଗରୁ କହିଥିଲା ଯେ ମୁଁ ସେ ଆସ୍ୟୁରାନ୍ସ ଦେଇଥିଲା ମୁଁ ସେ ପଡୋଶୀଠୁ ଟଙ୍କା ଆଣିକିନି ଆପଣଙ୍କୁ ଦେବି ବୋଲି ଯୋଉ ଧାର ଟଙ୍କା ଆପଣ ଦେଇଥିଲେ ସେଇ ସର୍କମଷ୍ଟାନ୍ସ ରେ ପୂର୍ବରୁ କଥାବାର୍ତ୍ତା ହେଇଥିଲା ଏବଂ ସିଏ ଯେତେବେଳେ ଆସିଲା ସିଏ ପଚାରିଲା ଯେ କଣ ଆଣିଛ ହ୍ୱାଟ ଡଜ ଇଟ୍ ମିନ୍ ହି ମିନ୍ସ ଦ୍ୟାଟ ଏ ଯୋଉ ଟଙ୍କା ଯୋଉ ଲୋନ ଟଙ୍କାଟା ଯୋଉ ମୁଁ ଦେଇଥିଲି ସେ ଟଙ୍କା ଆଣିଛ ସେଇ ବିଷୟରେ ପଚାରୁଥିଲା ସେଟା ଡିମାଣ୍ଡ ମନି କେମିତି ହବ
ଲୋନ କଣ ଯାହାକୁ ଦେଇଛନ୍ତି ତାଙ୍କ ପଡୋଶୀଙ୍କ ନାଁ ଜାଣିନାହାନ୍ତି ସେ ଚିହ୍ନି ନାହାନ୍ତି
that's a different matter though
ଆଉ ସିଏ କାହିଁକି ବରଡ କଲା ଟଙ୍କା 4000
that is why I'm telling that your witness is not consistent
yes, this witness is saying that I had brought the tented money by borrowing from others
then
तार बिल पास हवा पे से बोल करके आछि अन्य ମାନଙ୍କୁ ଯଦି ସ୍ତ୍ରୀ ଲୋକକୁ ଆଣିଥାନ୍ତା ତାହେଲେ ସ୍ତ୍ରୀ ଲୋକକୁ କାଲି ସ୍ତ୍ରୀ ଲୋକକୁ ପଇସା
7 towards the middle portion of paragraph 7 during our stay I noticed that the complainant was moving around the office premises you got it
yes
on my entrance to the office room of the accused I found some of the outsiders present inside the office along with the complainant after the complainant indicated me that he has made over the tented notes to the accused, I relayed signal to the trap party members. This again
after all that nearby house without any delay myself proceeded okay we waited for so and so before entering the during our stay notice the complainant was so and so on office room I found some outsiders present along with me that he had head over this property receiving the signal okay this particular 2 to 3 lines it excludes that kon anithilo beli se jota seguda seguda hey eta you during our stay what objection you have stated in your objection Mr. Das
yes I have stated my objection
given all
I have submitted my objection relying on the decision
corruption case so there should not be any stay that's
okay
basically
I am bringing it on Mr. Mundi will be available on 25th I have posted one of the case sei din rak debi ki all right 26 रे रहू नांती मिस्टर मूड इज नॉट देयर 25 तारीख कहउचंती 3:30 रे नवा पे so hard Mr. Smooth learning senior advocate appearing for the appellant and Mr. Sanjay Kumar Das, non-standing counsel, who submitted that he has already filed objection to the interim application. It is IA number 1723 of 2023. There is an application for stay of conviction. Tari heading rate likhideven. Mr. Moon, however, submit that he has received the copy of the objection from the London Standing Council. This matter on 25th September 2023. Matter will be taken up at 3:30 p.m. Registry shall place the objection on record. Yes.
next week, next 25 ପରେ ଯୋଉ 3 ପଡୁଛି 3 ତାରିଖ ଦିନ ଆଣି 3 ତାରିଖ
ପୁଣି ସାରିଲିଣି ଆଉ କଣ ଆଉ?
Vote is already.
3 ତାରିଖ. So your lordship is aware about.
Your lordship then see the objection.
On 3rd, may I pray before your lordship to take it on 3rd?
ପୁଣି ସାରିଲିଣି ଦେଖିବା ସେଦିନ ରଖି ଦଉଛି ଯଦି ଆପଣ କଣ ଲେଖିଛନ୍ତି କି ଅବଜେକ୍ସନ ହି କପି ମତେ ହ୍ୟାଣ୍ଡ ଓଭର କରିଦେଲେଣି ଆଉ ସେଇ ଗୋଟେ ଏତେ ଡିସିସନ କଣ ଲେଖିଛନ୍ତି ଗୋଟେ 14ଟା 15ଟା ଡିସିସନ
your lordship's observation decisions and also the latest 2 decision regarding that Om Prakash Santuka and Neeraj Datta.
ଆଚ୍ଛା ହଉ
Neeraj Datta and Om Prakash Santuka. All these factors.
ଥାଉ ଦେଖିବା. Yes, next.
74.
Delay of 52 days, my lord. And file IFR condonation of delay, my lord.
He has already filed objection. Yes.
And there is a delay of 52 days filing this appeal, my lord.
What is this?
Appeal is, my lord, 454(1), my lord, the direction of the trial court to confiscation of the vehicle, seizure vehicle, my lord. In page 25, my lord, last paragraph.
You are the informant or what?
I am the owner of the, my lord, son of the, my lord, seizure vehicle, the owner of father has been dead, my lord.
That has been directed for to be confiscated. That order you are challenging. So what delay has been pointed out?
52 days, my lord.
Because you have not made the accused persons as the opposite party. Are they not claiming this vehicle to be there?
This petition appellant is the accused, my lord. He was in custody after my lord acquittal, my lord.
Okay. He claims to be the owner of the vehicle.
Because father dead, my lord, in the meantime.
What do you say, Mr. Mishra? Delay paying actually.
The vehicle is involved in a case.
No, that will be on merit. Let the delay be condoned. IA number so and so is an application for condonation of delay. The stamp reporter has pointed out that there is a delay of 50 days in filing this appeal under section 454 of CRPC. After hearing the London Council for the respective parties, on perusal of the grounds taken in the interim application, I am inclined to condone the delay. Accordingly, delay is condoned. Place this matter next week for admission. Yes. IA disposed of the case.
On behalf of Udit Ranjan Jena, my lord,
Hmm.
here the appellant has been convicted under section 325 of the IPC and sentenced to undergo RI plus 3 years, fine approved to
Page relevant page.
my relevant running page 29, my lord.
RI for 3 years.
My lord,
Fine 2,000 in default to undergo
SI for 1 month.
1 month. 325.
And
No
under
separate
section-
sentence for 323.
My lord, under
Okay.
section 294
Then 1,000 rupees
1,000
under section 294
and
in default
SI
SI
for 20
for
days.
20 days.
And under section 341 IPC, sentence 500 rupees
500
in
rupees.
default of SI for 7 days.
Hmm.
And under section 506 part 1 of the IPC, sentenced to 2,000 and in default SI for 2 months. Only he was during trial period he was on bail.
No, you the wrong consecutively.
Consecutive.
Consecutively କେତେ ହେଲା? 3
fine ଅଛି.
also fine.
आगे.
अच्छा. So you were on bail during trial?
My lord. They arrested and subsequently released on bail.
All right.
And
IA number
7 days delay.
1795 of 2023. There is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 8 days.
7 days.
8 days in filing this criminal appeal. After hearing the learned counsel for both the parties and perusal of the grounds taken in the interim application, and since it's a case of conviction where substantive sentence of 3 years have been imposed by the learned trial court, I am inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of hard admit. He was on bail, so bail granted. Stay realization of fine. Okay, Mr. Mishra, I'm just coming within 1 minute. Acha.
But item 78.
78, the stamp reporter has indicated that it should be a BLAPL, not CRLA.
Because I have filed CRLA because I have challenges the order of the OPID court under section 13 of OPID Act, and section 13 says, my lord, any person, including the competent authority, if aggrieved by an order of the designated court, may prefer an appeal to the High Court within 30 days from the date of the order. For that, my lord, I have filed CRLA.
So this is virtually a bail application because you claimed for bail on the ground of default.
My lord, prayer of bail is the secondary prayer. My lord, my first prayer is to direct the IO to submit the charge sheet, which he has submitted a preliminary charge sheet um, with, before completion of the investigation.
You come to the that first paragraph of the order
My lord.
dated 21/7/2023, wherein it is mentioned that this petition has been moved on behalf of the accused petitioner Alok Kumar Das, praying for release him on indivisible right of bail, and another petition dated 11/7/23 moved on behalf of the accused to direct the IO of the case to submit charge sheet for only trial of the case, and till then the court may so and so for framing of the charge. So as it appears, you moved two two applications. One is for that default bail, the other is for a direction to the IO. And the operative part, the court has rejected your applications. So against that, you have come up. And if you see your CRLA petition, the prayer portion you have mentioned that set aside the order dated so and so and direct the IO to submit charge sheet and consequently further be pleased to direct the. So again, joint prayer has been made.
My lord, if your lordship is allowing the first part, then only the question of default bail is coming forward.
Default bail, if the charge sheet is not filed within a particular period, taking into account the punishment prescribed, then the 167 to
In this
proviso would come.
charge sheet,
Some point. So that is how the London OPID Act court, he has relied on decisions of this court as well as of the Honorable Supreme Court that in such a situation, the accused is not entitled to get the benefit of default bail because charge sheet has been submitted, cognizance has been taken. What it is pending? It is pending for the further investigation report. The permission has been granted for carry out the further investigation, and 173(8) it says so. So it cannot be said that when the charge sheet is filed and cognizance is taken, you are entitled to default bail. That is the law which has been decided. Whatever it may be, the question is that it has been pointed out that since you are praying for this bail, you have to file a bail application. Now, for two prayers, you cannot make one application. If your application is you have filed two separate applications and two prayers have been turned down. So you have to file two separate applications here, challenging each rejection order. You have filed one, and it is pointed out by the that BLAPL and division bench has already decided that in OPID Act matter, if you want bail, you should not come under section 13 of the OPID Act. You have to file nomenclature would be BLAPL. That is already decided by this court.
Then your lordship may direct the registry to change.
No,
the
it is not
nomenclature.
registered. You are to file an interim application to for conversion of this CRLA to BLAPL.
All right, my lord. Filing.
In view of the report of the stamp reporter that against the impugned order, BLAPL is maintainable, the London Council seeks some time to file an interim application for conversion of the CRLA to BLAPL. Yes, list this matter immediately after the interim application is filed. Yeah.
My lord.
$79. May I please?
I have for condemnation of delay, your lordship.
Is
Delay
a case of conviction, appeal.
My lord.
What is the sentence imposed?
Convicted under section 304 part 2 and sentence, your lordship, arrive for 8 years and fine 5,000 rupees, your lordship.
Yes, Mr. Mishra,
Yes.
25 days delay. So delay condo, admit, call for the trial court record, interim applications for bail and sterilization of fine to be considered after receipt of the trial court record. Deposition copy be supplied to the London Council.
I am
Yes.
sorry, your lordship.
You have supplied, acha, deposition copy supplied in court for them.
I would.
Yes. It will come after 1 week. Yeah.
My lord.
I एटाও dispose of कर देगा. Yes.
81.
The petitioner is convicted.
May I please, your lordship? My lord, appellant has been convicted under section 354A of the IPC and under section 8 of the POCSO Act, my lord, and sentenced under section 8 of the POCSO Act for a period of 5 years, my lord. Page 30 of the running page 30.
Running page 30.
13. He was on bail during trial, ma'am.
Just. Okay, paragraph number 20. Convict is sentenced to undergo RI for 5 years, fine of rupees 3,000 under section 8 of the POCSO Act, in default to undergo RI for 6 months. Okay, you were on bail during trial.
Yes, ma'am.
And what is the delay? It has come for condonation of delay. The delay is for 13 days. Okay. Yes, Mr. Mishra.
Yes, sir.
So delay is 13 days. Delay condone. You admit he was on bail. Bail allowed. Oh, state relation of fine. Yes.
85,
Yeah.
93.
It's a bail application. SC Act is there.
Notice sufficient
Madam.
ହେଲା କେବେ
21
ଆଚ୍ଛା
My lord.
ଫାଷ୍ଟ ବେଲ୍ ଆପ୍ଲିକେସନ ରିଜେକ୍ଟ ହେଇଛି କାହିଁ ଅର୍ଡର କାହିଁ What is the number of that application?
This is first application, lordship.
Oh, first application.
Yes.
Oh, then it's all right. Okay. What
Not
is the
this-
date of
this-
custody?
Custody since 1st of March 2023, lordship.
Let it be, my lord. Next week, my lord.
Hmm.
Receive the CD, my lord.
So city finance. Offense କଣ?
302, my lord.
302, 326A is there, but I am not the principal accused.
The list this matter in the week
Third, my lord.
3rd of October 2020. ऐसे ऊपर लिखी हुई है, the Learned Counsel for the state submits that notice on the informant has already been made sufficient since 21/8/2023. Stop. Non-appears for the informant. He further submits that he may be given some time to obtain the case diary and instruction regarding criminal antecedent, if any, against the appellant. List this matter in the week commencing from 3rd October 2023. Yes, obviously.
94.
94, my lords, may it please your lordships. This is a bail application, my lords, under section 14A. On the last occasion, your lordships had directed me to serve extra copies so that notice could be served.
कौन है ला?
My lord.
Notice sufficient.
94 to my lord.
CRLA number 781 of 2023.
Kindly pass it.
Pass over. All right.
$95.
95, Mr. Deepak Kumar Sahu. Case diary पाई जल्दी
95, my lord, 9.
नहीं
9.
offense कौन?
Notice of, my lord.
Or
307.
along with my lord SC/ST Act.
notice के पे sufficient
19 8.
हाँ
19 8.
19/8. तो जम किस case diary पाई ना थी?
No.
My lord, I am in custody since 21/6/2023.
कितने जन injured?
My lord, injured. My lord,
Have you got the certified copy
Yes,
of the injury report?
my lord.
देखान सेठी देखान मिस्टर दास
My lord.
से इरा देखिले से के जन इंजुर्ड अछंदी आ इंजुरी रिपोर्ट सब अवेलेबल अछि ना नै कोन नेचर ऑफ इंजुरी कोन
Yes, that's my lord. Simple. Simple man. And Raghunath also.
Simple, my lord.
केते जन इंजुर्ड अछंदी
Injured man.
1 2 3 4 जन
Mahendra Singh that was it. Mahendra Singh.
नो नो ए आर अछि कि देखिले कुसुम दास रो
मैंने कुसुम दास अछि
कारण एफआईआर लिखा हिची
मारा हॉस्पिटल रे हेची सिंपल मारा
हाँ कुसुम दास स्वामी मुरली दासଙ୍କର ଅବସ୍ଥା ସଂକଟପନ୍ନ ହେବାରୁ ତାଙ୍କୁ ନିଶ୍ଚିତ କୋଇଲି ଡାକ୍ତର ବାବୁ ତାଙ୍କୁ କଟକ ରେଫର କରିଦେଇଛନ୍ତି ସେ ବର୍ତ୍ତମାନ କଟକ ମେଡିକାଲରେ ଜୀବନ ମରଣ ସହିତ
सिंपल
ସଂଗ୍ରାମ କରୁଛନ୍ତି ରେଫର କିଛି ହେଇଛି ତା ଦେହରେ
सिंपल इंजरी हेची लासेट इंजरी हॉस्पिटल एरिया कॉल
ओके
Rasmita Das also simple matter.
The Learned Counsel for the state submitted that the notice on the informant has been made sufficient since 19 8 परा कहले
Matter
19/8/2023. Stop. Non-appears for the informant. The London Council for the State, the injury report has produced the injury report of so and so, from which it reveals that the injured persons have sustained simple injury. London Council for the State submitted that though in the first information report it is mentioned, FIR copy ଆପଣଙ୍କର annex ହେଇଛି ତ? Mr. Das? That one Kusum Das has sustained serious injuries for which he has been referred to from Nishchint Koil Hospital to Cuttack, and her condition is alarming, but the injury report indicates that she has sustained simple injury. Considering the submission made by the Land Council for the respective parties, nature of accusation against the petitioner, appellant, nature of injury sustained by the injured persons, and period of detention of the petitioner in judicial custody. I am inclined. केबेट रहिଛନ୍ତି ଲେଖା ହେଇଛି ଉପରେ 21/6/2023 है ना 21/6/2023. I am inclined to release the petition on bail. Yes, allowed. Next. The injury report radele.
96.
96, my lords. May it please your lordship. This is also for bail, my lords. The section 14A. This is.
Yes, Mr. Das.
My lord. Next week, my lord, reading the notice and the CD, my lord.
My lords, CD may be available, my lords, of a co-accused person. His bail is also pending, my lords. It is on the list. That is item number 207, who is the main culprit. That's item 207, my lords, of your lordships weekly list.
Verify कर दियो.
CRLA number 563 of 2022. 563 of 2022. That is in your lordship's list.
200 कितने?
207, my lords. Item 20.
देखी दियो तो next week
can it be on Tuesday, my lords? Tuesday, 26th of September.
Oh, Tuesday for them. 26/9/2023. Land Council for the State submitted that matter may be taken up next week to us obtain instruction whether the notice on the informant has been made sufficient or not. Land Council for the appellant submitted that one of the co-accused has approached this court for bail, and the said case, that is CRL number 563 of 2022, is sub judice and listed today for as item number 207, and the case diary might be available in the said record. Land Council for the State seeks some time to verify the same. This matter along with CRL number 563 of 2022 next week.
Can it be on Tuesday, my lord? Date maybe.
Next week at the 26/9 with CRLA 563 2022. Yes.
$97.
May please your lordship.
Your Lordship, my lord.
Yeah.
My lord, the appellant is in custody since 26 2023.
Just is a 14A application.
Yes, my lord. SCST.
No, notice sufficient.
Sufficient, my lord. 13.8.
Wait. Yes, Mr. Das.
My lord, Otterat.
Is sufficient. What is the date of custody?
26 2023, my lord.
26
Agya.
2023. Charge sheet chalani.
Charge sheet he yechi.
What are the offenses?
4, my lord. Running page number.
You have filed the copy of charge sheet.
Yes, my lord. Running page number 27, annexure 4, my lord.
All right. 341, so on. Okay, 307 is there. All right.
This ERLA, my lord, 440 of 2023. 440 of 2023, my lord. Co-accused has been released by my lord.
440. Kirod Vishwa.
My lord.
So on. All appeals are okay. March ingredients of the offense counsel. The informant Lakhan Shah is injured in the eye. Already been discharged from the hospital, is quite ill and hurting. Unnamed responsible has already been released on bail. Okay, heard the learned counsel for the appellant learned counsel for the state learned counsel for the state submitted that notice on the informant has been made sufficient. None appears for the informant. Then you mentioned the date of custody to be 20/6/2023. बाकी से जो ऑर्डर अच्छी 440 या अन्य ऑर्डर सेଗୁଡାକର annexure 6 से ଦେଇଛନ୍ତି ତାକୁ ଦେଖିକିନି କରିଦେବେ ଏବଂ ତା ଦେହରେ ଗୋଟିଏ ବେଲ୍ ଅର୍ଡର ତା ପୂର୍ବରୁ ଯୋଉ ବେଲ୍ ଅର୍ଡରଟା ଲେଖା ହେଇଥିଲା ତା ସହିତ ଏଇ ଯୋଉ 440 ସହିତ ଅନ୍ୟାନ୍ୟ ବେଲ୍ ଆପ୍ଲିକେସନ୍ସ ଗୁଡାକ ନମ୍ବର ମଧ୍ୟ ଲେଖିଦେବେ that was disposed of on 3/7/23 when the co-accused persons have been granted bail. Then बाकी जहाँ contention सब रही सेम कर दिया अलाउ कर दे.
Obliged, my lord.
$99.
Yes, Mr. Sahu.
Lordship, my lord. This is 14 application, Lordships.
I am for the opposite party, madam. I am for the opposite party. Copy not received.
Siddharth Samal is the counsel for the appellant. Okay. Is not the K na. ऐसे गोटे K गोटे कौन रहुची ताको से पूरा ना न देले उड़ाई देउ. हाँ. Non appears for the এটা আজি টেক অফ ହେଇଥିଲା ନା ଗତକାଲି ଟେକ୍ ଅଫ୍ ହେଲା କେହି ନଥିଲା ଆଚ୍ଛା non appears on repeated call learn and counsel for the non appears for the appellant କରିଦେବେ ହେଲା learn counsel for the informant submitted that he has not received the copy of the appeal memo along with the annexed documents. We have also noticed. So also the learn and counsel for the state. The learn and counsel for the appellant shall supply the same to the learn and counsel for the state as well as learn counsel for the informant. You have received the case diary?
No.
The learn counsel for the state shall produce the এটা কোন কনভিকশন কেস কনভিকশন
লিমিটেশন পিটিশন টা খালি নোটিস রে ମୋ ପାଖରେ ଅଛି
আচ্ছা ନାଇଁ ନାଇଁ ସେ
লিমিটেশন ରେ ଯାଇଥିଲା ବୋଧେ নোଟିସ ଟା
main
Judgment dated like that.
No, here he has to supply you the deposition copies. Supply the deposition copies खाली करूँ से जो केस डायरी टा काटी दें है ना ये এটা नहीं जान तो 9th October को नहीं जान 9/10/2023 yes.
$71.
notice regarding notice, my lord, suffice.
SC/ST.
94 my lord, service notice on 21st 8 2023.
Just a minute.
My lord.
94, that is CRLA 781/2023. Notice sufficient. केबे डेट कहले
my lord 21 8
custody since
Custody, my lord, since 4/5/2023.
charge sheet कौन सा?
Charge sheet, my lords, 147, 148, 294, 506, 300.
Just a minute. You have not filed the copy of charge sheet. All right.
my lord in CRLA 231 of 2023.
231. Kahin order copy kahin?
My lords, I am giving the order copy.
Ano? अच्छा ये मैंने एक्सेलेंट को चिन्ही पारलेनी जेतु मास्क पिन
My lords, in the meantime, my lords, one of the main assailant, my lords, has already been released on bail.
has no criminal until supervisor offense once. Same footing अछि notice sufficient कर दूं 21/8/2023 रे non appeals custody date होची 4/5/2023 बाकी देखिए ना आते करिवे ए जो तादेर से जो अन्य सहित याकू मिसेई देबे गुडा का अलाउ हिची बे हैना yes
Deeply grateful.
सेठी पाई जाए गला
87 टा
सॉरी बुझी गेल हां असिल लॉन्च कर गयो 80 कोन हला
87 टा
87 टा कहले आफ्टर लॉन्च कहले हां बाकी रेस्ट ऑफ द मैटर आफ्टर लॉन्च
Item 87.
Wait, please, Your Lordship.
Item 101,
100টা ছিল আপনার
100, hundred one,
এটা প্রেস হবো along with the report of 101, no one is there. All right, pass over Pranam. Then
102,
102, Mr. D.P. Dhar, Prafulla Chandra Acharya. Pass over.
103,
During pendency of the appeal, sole appellant died. The present petitioner is the wife. File a petition to implead as a party and giving opportunity to hearing the appeal.
IN number 1915. Have you given a copy to the London State Council?
1916. Copy there.
Dina di?
1916.
हाँ. So you are the
wife of the appellant.
So,
Relation in I.
where is the legal heir certificate? And when the death took place, where is the death certificate? No, don't give like that. That is not the way. You are to annex all these documents to that interim application.
Next
Or
week,
you have already filed and not annexed, then you are to file an additional affidavit.
let's say let you come next week. I will file the additional
You are to
affidavit.
file the death certificate. You are to file the legal heir certificate, so that this 394 CRPC petition requires to be filed within 1 month from the date.
Let's see.
If it is delayed, then you are to file application for condonation of delay in filing that application. So when your husband died, that means the appellant died.
9/3/17.
So 9/3/17 is the date of death. You are filing the interim application in 2023. So you are to file a delay condonation application and explaining why there is delay.
Let's see. I will file the next week.
And it's a vigilance appeal. So you are to serve the copy not on the Learning State Council, but maybe Mr. Das or anybody.
Let's see.
You have not served the copy on Vigilance Council.
Not sorry.
State को तो देइछन्ति ଆଉ Vigilance
एप्रिल में mo लिखा दिया आए कॉपी दे
से आए तो
से Mr. Sanjay Das अछन्ति connection लगेले तो
in course of day.
Yes, my lord, I am here.
That matter is actually a vigilance matter.
My lord, year, my lord.
This is 2015.
So, Josna Tripathi to be served with copy.
अच्छा. The IA number 1915 of 2023. This is an application for impleading no. The prayer is also defective. Are you not reading the section itself? You have to file an application for leave to continue the appeal. That is the wording 394.
Let's see. Let's see, may permitted to withdraw and file better application along with the
394 2 and the proviso it reads like this. Provided that where the appeal is against conviction and sentence of such and such of imprisonment, and the appellant dies during the pendency of the appeal, any of his near relatives may, within 30 days of the death of the appellant, apply to the appellate court for leave to continue the appeal. And if leave is granted, the appeal shall not abate. So you are to file an interim application for grant of leave to continue the appeal, and in that interim application, at least the main requirements is that you are to make an averment that the appellant has died. In support of that, you are to file the death certificate. Second is that you are the legal heir or the near relative. For that, you are to file a document. Then, if it is leave is granted, then matter is appeal will not admit. And if it is beyond the period of 30 days, which has obviously taken place in this case, then you are to file another interim application for condonation of delay in filing that IA for leave. So you withdraw it.
Let's see.
IA number so and so. This is an application for impleading the proposed appellant as appellant number 1A. Though this application has been filed under section 394 CRPC, but since there is no required averments in the interim application and required documents have not been filed, and it is filed beyond the period of limitation without filing an application for condonation of delay, the learned counsel for the appellant seeks permission to withdraw this IA to file a better one. Accordingly, IA is disposed of.
May I pray, my lord, vigilance may be reflected in the cause list.
Since it is a the appeal is filed challenging the judgment and order of conviction passed by the learned Special Judge Vigilance Barampur in GR case number 14 of 2007 bracket B in the cause list after state of Orissa within bracket vigilance be mentioned, and since it is stated by Mr. Sanjay Kumar Das that 2015 criminal appeals have been allotted to Mrs. Joshna Rani Tripathi for argument on behalf of the Vigilance Department, on behalf of the state of Orissa Vigilance Department. Her name may be reflected in the cause list henceforth. List this matter immediately after the interim applications are filed, serving copy on Mrs. Tripathi. A free copy of the order be handed over to Mrs. Tripathi. Yes.
for an interim bail. The last your lordship was pleased to direct for grant of interim bail on 14/11/2022 for a period of 4 months, and thereafter I have surrendered on 23rd of March 2022. Your lordship, now due to the ill health of the appellant and due to get her daughter married, the appellant.
Which is your present application?
Lordship, IA 1161.
Mr. Tripathi, have you received a copy?
No, my lord.
And what grounds you have taken?
Lordship, to take care of her ill mother and to get her daughter married. Lordship, we have served on 10th of May 2023 in the AG's office.
Whether he surrender or not, my lord.
Lordship, the surrender certificate
Surrender
is at
certificate.
page 9 of the IA.
That is there. But first of all, solve that IA copy.
Lordship, I'll hand over one more copy. I don't have
Learning
extra copy.
IA number 1161 of 2023. This is an application for interim bail on the ground of mother's ailment as well as to get the daughter married. Let a copy of the interim application be
Extra copy.
Let a copy of the interim application be served on the Learning Council for the state by tomorrow.
Lordship.
By tomorrow, on receipt of which the Learning Council for the state shall obtain specific instruction on the amendments taken in paragraph number 5 of the application. Paragraph 5 रे लिखा है मिस्टर त्रिपाठी से विषय रे ये जो मारो एलिमेंट विषय रे आउ झियोर मैरिज विषय एटा टू गेट हर डॉटर मैरिज कौन लिखे बराबर पुरुष लोड़ा
Lordship, typographical error.
Okay. The Learning Council for the petitioner submit that in paragraph number 5 ऊपर लिख देवे. In place of her, he may be permitted to her daughter, he may be permitted to correct it as his daughter by scoring of her. Permission is granted. एहड़ा दे दियो से जो खाली her टा ऊपर उड़गारो पकेवे he is लेकिन signature आज रो date पके दो. So it will come on 3rd of October 2023.
Lordship, can I pray for a week thereafter?
So 10th, 9th October.
Great.
9th October 2023. Copy of IA to be solved. Yes.
Grateful.
107.
Mr. Sapan Kumar Lenka.
Appellant is in convict under section 22B WIC of the NDPS Act. 10 years, my lord. Out of 10 years, he is in custody, my lord. 16/10/2015, my lord. Paper book is ready and it was previously ordered to list it for hearing.
Aguru bail le jayi nathile ki?
I was in interim bail and surrender in time, my lord.
So now which application you are placing?
My lord, IA 1922 for 23.
So apart from that particular IA, there are other two IA mentioned in that cause list. So here in 498 of 2018, so how many appellants are there? Only one appellant, Pintu Singh Sahu. So for one appellant, why have you filed 3 bail applications?
No, my lord. There is a common trial, 3 appellant, my lord.
No, I am not on that. So far as the CRLA number 498 of 2018, that indicates that only Pintu Sahu is the appellant.
My lord.
Is it correct or not?
Yes, my lord.
So for one appellant, Pintu Sahu, why have you filed 3 interim applications for bail?
There is a prisoner petition. Thereafter, I am filing this IA, my lord.
So you have to not press the other 2 applications for bail. अरे गोटे करिबे ना 3टा कोन एप्लीकेशन फाइल जदी 2टा आगुर के फाइल हे जाई जी ताकू नोट प्रेस कला परे सिना आपनकर हार्ड एप्लीकेशन एंटरटेन हबो लेखंदु आईएन नंबर 1231 of 2020 and IN number 57 of 2020. The Learned Council for the appellant does not want to praise this application, disposed of as not praised. Now 1922 of 2023 आपनकर कोन कहिवार अछि कोंतु.
I am custody, my lord, 6/10/2015, my lord.
6/10
2015.
हाँ.
And I'm already 10 years conviction, my lord. I am
हाँ.
already
No no केते थर इंटरिम बेले जाइछन.
one time, my lord.
केबे गले ऑर्डर डेटेड केते.
I am released on bail 23/3/23.
23/3/23.
21/2/22 रे गोटे ऑर्डर हेतला
Wait.
इंटरिम बेल
नहीं तो ए देखिलो केबे इंटरिम बेल जाइछो.
21/2 देखले
नहीं 21/2 रे किछ.
सॉरी 21/12
21/12
22
ना 21/12 टिके रहो. Considering so and so हाँ 3 months होची 21/12/2022 आउ तापर जाइछन बेल इंटरिम बेल.
My lord, I avail that 23/3/2023.
ओहो आपण केबे जी अवेल करे दैट्स
तापर
डिफरेंट बात.
Nice.
तापर आ बेल
ना.
ऑर्डर पास हे जी तो
ना,
सेही ऑर्डर टा बळ रे सेटा जोटा हेइतला 21/12/2022 रे सेही ऑर्डर बळ रे आपण मार्च मास रे बेल गले.
Yes, my lord.
Obviously 3 मास परे पुनी सरेंडर गले
Exactly, my
ना
lord.
पुनी
No, same day, same man. Surrender on 26/3.
तापर बेल ऑर्डर ना.
23/6.
ओके. So where is the surrender certificate?
I'm filing IA, my lord.
ये प्रेजेंट आई रे फाइल कर देन.
Page 6.
1922
My
देखिले.
lord.
1922 रे सरेंडर सर्टिफिकेट काई 23/6/2023. अच्छा. Pintu Sahu present. As per our director, the surrender is accepted. Okay. Paper book तो ready है.
I am already 7 years 9 months.
All right. Look on the IN number 1922 of 2023. This is an application for bail. Under section 389 CRPC, the Land Council for the petitioner submitted that the petitioner was taken into judicial custody in connection with this case for the first time on 16/10/2015. And during trial, you are not on bail.
No, my
देखिए और ट्रायल कोर्ट रिकॉर्ड वन
custody certificate is there.
हाँ अच्छी पास करूँ देंगे कितने होची था
7 years 8 months 9 months.
Stop. And the petitioner has already undergone more than 7 years and
तो ऊपर का
into South 9 7 years and 9 months. Out of 10 years of sentence passed by the Learned Trial Court, he further submits that the petitioner was released on bail, interim bail, for a period of 3 months, as per order dated 21/12/2022 in IN number 2235 of 2022, and after availing the same, he surrendered at right time. Land Counsel for the petitioner has annexed the surrender certificate to the interim application. It is further submitted that though the paperwork has already been prepared, but there is no chance of early hearing of the appeal, and therefore, in view of the ratio laid down in the case of so and so, the petitioner bail application may be favorably considered. The Learned Counsel for the state has produced the custody certificate dated 18/9/2023, issued by the Senior Superintendent Circle Jail, Berhampur, from which it appears that as on that day, the petitioner has already undergone 2804 days. ନାଇଁ କାଟି ଦିଅନ୍ତୁ ହଉ ଠିକ ଅଛି ସେଟା ଥାଉ ବ୍ରାକେଟ ଲେଖନ୍ତୁ 7 years 8 months and 4 days. Considering the submission made by the Learned Counsel for the respective se decision ଟା quote କରିଦେବେ ତାପରେ କରିଦେଇକି ଏଟା କରିଦେବେ bail allowed.
IA 1923
stay realization of fine.
IA 1923 of 23 criminal law bill 565 of 2018.
କୋଉଟା
ସେଇଥିରେ connected ତିନିଟା with
ଓହୋ ଆଚ୍ଛା 1923 ଏଇଟାରେ ପୁଣି କେବେ କେବେ
same day ରେ ଗଲୁ same surrender same custody.
କାଇଁ ତାର କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ କାଇଁ ଆଦିରେ ବି ସେ ବେଲରେ ଯାଇଥିଲା ଇଣ୍ଟରିମ୍ ବେଲରେ
ଆଜ୍ଞା ଆଜ୍ଞା
ତାର ଡେଟ୍ ଟା ଦେଖି ଦେଇକି ଲେଖିଦେବେ ସେମ୍ ହୋଇକରି ଆଇଏଟା ଆଲାଉ କର ଆଦିରେ ଷ୍ଟେ ଆପ୍ଲିକେସନ ନାହିଁ ଷ୍ଟେ ରିଲାଇସନ ଅଫ ଫାଇନ୍ କିନ୍ତୁ ଆଦିରେ ଅଛି ଖାଲି ଆଦିରେ ବେଲ୍ ଆଲାଉ ହବ ଅଲରାଇଟ୍ ନେକ୍ସଟ ଆଉ ଗୋଟେ
760 ଆଉ ଗୋଟେ 1924
1924
ଇୟର 760
କିନ୍ତୁ ପଲ୍ଲେଇ ଦେଖ ନାଟା ଦେଖ ନେମ୍ ଅଫ ଦି ପ୍ରିଜନର ଲେଖା ହେଇଛି ତା ଦେହରେ ବି ଇଏ ଯାଇଥିଲା ଇଣ୍ଟରିମ୍ ବେଲରେ
ଏକା ଦିନରେ ଆମେ ଯାଇଥିଲୁ ଆସିଲୁ
ଠିକ ଅଛି ତ ବେଲ୍ ଆଲାଉଡ୍ ଯୋଉଟା ଯେ ଯାହା ଫାଇଲରେ ଯେ ଯାହା ରଖିବ ଏ ଉପରେ ନାଁ ଗୁଡା ଲେଖା ହେଇଛି
Your Lordship has released the petitioner 3 months in that bail. And
surrender certificate.
File
Yeah.
surrender certificate. And in this case also, my lord, they have inside the custody for 7 years.
No, where is the IA?
Main IA is pending, my lord.
Kain, nahi to?
Main IA, my lord, is not disposed of.
You are in CRLA number 82 of 2019.
82 no, my lord. My name is 548.
Second item.
Second item no gotiye matra IA pending hoji stay realization of fine. That is 548 of 2018.
So I will file
All right,
next week, my lord.
वो आज जो surrender certificate फाइल कले वो उथरे फाइल कले
4 ଜଣ ସେଥିରେ ଅଛି 4 ଜଣ
अच्छा तमने जो
82 ଟା ମଧ୍ୟ my lord senior Ponda is also surrender on that same day.
नहीं सी तो surrender certificate produce करना है आप
ଏଇଥିରେ ଲେଖା ହେଇଛି ସବୁ
लिखा है जी all right CRLA number 548 रे order कर दियंतु Learned Counsel for the petitioner files the surrender certificate which is taken on record है ना आओ IA number so and so this is an application for stay of realization of fine सेटा allow कर दियंतु stay fine okay तापरे 589 स्टे पिटिशन टाको अलाउ कर दियंतु स्टे फाइन आ गोटा रही 13143 of 2018 there भी स्टे फाइन अलाउ बाकी आउ तो इंटरिम बेल किछि नाही
मैं अच्छी मु आए फाइल कर 2018 रे सबुथरे
खोजी कि देखंतु ये करी कारण लिस्ट रे आसीनी ना
अच्छी बेल आउ ये रे दीटा कर फाइल कर
बेल हुए तो डिस्पोज ऑफ हे
ना सेटा
हेनी
ना इंटरिम बेल आपण डिस्पोज ऑफ करछन सेटा
ठीक है नेक्स्ट देखि दियंतु के रेकॉर्ड गुडा को वेरीफाई कर दियंतु जदि थिबो डिस्पोज ऑफ न हिथिबो ताले से गुडा को से आईए कंसीडरेशन पे आसीबो जदि नाही सर जाइथिबो तो फ्रेश आईए फाइल करियो यस नेक्स्ट
109
Mr. Sahu.
110.
My lord, in I number 1503 of 23 flag D, my lord. It is not pray for fixing an early date of hearing, my lord. Paper books have been filed. Vigilance.
What is this offense?
Offense is 409. Offense is 409 IPC and section 13(1)C of the Prevention of Corruption Act. The main accused has expired, man. Now the legal heirs have been allowed to contest, and since the pensions have been held up, my lord, the wife has been implemented.
ସେ ତ ଯେତେକ ଭିଜିଲାନ୍ସ କେସ୍ ଥିବ
My lord.
ସେ ତ ସବୁଥିରେ ପେନସନ ଇଏ ହେଇଥିବ
And the case is something different, my lord.
କଣ ଆଉ ଡିଫରେଣ୍ଟ କଣ
Different means the
2019 ର ଆପଣ ଏଇଟା ଅପିଲ ଟା ନା
my lord.
ବର୍ତ୍ତମାନ ପୁରୁଣା ଅପିଲ ଗୁଡା ପେଣ୍ଡିଂ ଅଛି ଆପଣ ପେପର ବୁକ୍ ଟେ ତିଆରି କରି
we
ଫାଇଲ
have
କରିଦେଲେ ମାନେ ନୁହେଁ ଯେ ସାଙ୍ଗେ ସାଙ୍ଗେ ଆପଣଙ୍କର
the whole difficulty is now we are deprived of the pension. My lord. That is good.
have you must have seen in the hearing list how many old appeals of the vigilance are pending, not only trap cases but other cases. So we are taking seriously, but out of turn, if we take, then there would be complaint of the old appeals that are not being taken up.
Because they are
New appeals.
they are in
Difference
hardship.
କଣ?
My lord,
ସେମାନେ ବି
hardship.
conviction ପରେ ତାଙ୍କୁ ବି dismiss କରାଯାଇଥିବ ତାଙ୍କର ଯଦି
But in
return
this case, what happened? The husband was working as an headmaster. Man. He had taken some money. Money has been
ପୂଜା ପରେ ଏଟା consider ହବ ଲେଖିଦିଅ
my lord.
IA number 1503 of 2023. This is an application for fixing an early date of hearing. Matter to be listed after Durga Puja vacation for consideration of the IA.
On behalf of Mr. Maharana, I am here, man.
अच्छा मिस्टर तांको ना लिखिबि ना आपण ना लिखिबि
ଯାହା ନା ଲେଖିଲେ ଚଳିବ ସେ ଇଜ absent.
Mr. Sanjay Kumar Das, Learned Standing Counsel for the Vigilance Department, is present and submitted that Mr. N. Maharana, Additional Standing Counsel, is not well. After Durga Puja holidays, yes.
Oblige, man.
$111.
File I flag E. I number 1908 of 2023 flag E. Out of 10 years substantive sentence, as on today, he has already gone 7 years, 10 months, 2 days.
And you custody certificate.
This is a case of NCV, Central Government Agency.
अच्छा ताकू कॉपी देई ना दी आपण so okay judgment टा पड़ाला हाँ राइट नार्कोटिक कंट्रोल ब्यूरो तार गोटे पैनल काउंसिल अछंती का पैनल माने एई माने करूछंती जो सेंट्रल गवर्नमेंट काउंसिल करूछंती देई दियन गोटे कॉपी देई दियन तो
In course of the
हाँ since the central government council is to represent the respondent, Learned Counsel for the appellant submits that he will supply the copy of the appeal memo along with the impugned judgment and interim application to the Learned Additional Solicitor General.
A copy of memo has already been served because from the earlier order, yes, it indicates Gyanalok Mahanti.
Yes, yes, Gyanalok
Mahanti. Gyanalok Mahanti.
Yes, yes.
Acha, you will serve Khali IL. Copy of the interim application will be served on swan. So, bracket henceforth in the cause list, it be mentioned that in the respondent advocacy Central Government Council, CGC to be mentioned all that.
Maybe next week it will come.
Okay. Please this matter next week.
Hundred
112, Mr.
Hello.
Yes.
And the appellant was on interim bail on 24/1/23 for a period of 3 months. And he has surrendered. For that reason, my lord, I have filed interim bail for another
No,
3
no,
months.
it's all right. Have you filed that surrender certificate?
Yes, he surrendered 2/5/23.
ଆରେ ଆପଣ ସିନା କହି ଦଉଛନ୍ତି ତାର ପ୍ରମାଣ କଣ ଅଛି ଯେ ସରେଣ୍ଡର କଲା ବୋଲି ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟଟା ହେଲେ ସେଟା ପ୍ରମାଣ ମିଳିବ ଦେଖେଇଲେ ସେ ଯୋଉ have you annexed that when you are released on interim bail by which order?
IA number 1448/2019.
କେବେ ଡେଟ୍ ଟା କେବେ କୁହନ୍ତୁ?
24/1/23.
ଆଚ୍ଛା 24/1/23
8/23 देखिए
1
8/23
ହଁ ଏଇ ତ 24/1 ରେ ସେ ବେଲରେ ଯାଇଥିଲା 3 ମାସ ପାଇଁ ମାନେ ସେ ଅର୍ଡରଟା ହେଇଥିଲା ଆପଣ କହୁଛନ୍ତି 1/8 ଲର୍ନିଂ କାଉନ୍ସିଲ ଆଚ୍ଛା ଫାଇଲ୍ ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ ଓକେ ଦ୍ୟାଟ୍ ଇଜ ଅଲରେଡି ଫାଇଲ୍ ଦେନ୍ ଆଉ ଗୋଟେ ଫାଇଲ୍ କରିଛନ୍ତି ଇଣ୍ଟରିମ୍ ଆପ୍ଲିକେସନ
ଆଜ୍ଞା 1887/23.
right so what is the sentence imposed by the London trial court and how much sentence you have already undergone if you exclude that 3 months what is your
15 years
calculation?
of imprisonment and 15 years and fine of 1,50,000.
Just a minute, let us see that. Operative part of the judgment. Mr. Tripathi, last page को नहीं ऐसा?
yes
वकालतनामा मार दिया, back कर दिया. हाँ, 15 years and pay fine of rupees 1,50,000.
yes
And in default it is 2 years. So what is the what sentence you have already undergone? Have you got the custody certificate?
no मिला
So get it, Lakon. IA number 1887 of 2023. This is an application for bail. The learned counsel for the state 1 week time to obtain the custody certificate of the appellant Dilip Kumar Adhikari. से କୋଉ ଜେଲରେ ରହୁଛି ବର୍ତ୍ତମାନ?
Abjal Digpahandi.
Okay, from the superintendent sub-jail Digpahandi. List this matter in the week commencing from 3rd October 2023. Yes. Okay.
113.
I'm just coming with you. Yes.
113.
Results. Petitioner is convicted under section 15C of NDPS Act for 10 years, my lord. And out of 10 years, he has already suffered more than half of the sentence. And this honorable court has also granted interim bail for a period of 4 months. He has already, my lord.
When you are granted interim bail?
5/12/22.
So, where is your surrender certificate?
My lord, I am filing the surrender certificate in time, my lord, and not violated.
And what is the period?
Custody certificate.
5 years, 1 month, 27 days.
আজ 30/11/22.
30/11/22.
Oh.
And during trial.
30/11/22 মানে তারপরে এটাতে যাইছেন না?
Yes, sir. And also, my lord, during trial, the appellant was also on bail.
Oh, particular. 30/11/22 মানে তারপরে 3 মাস যদি avail କରିଛନ୍ତି এটা 3 ମାସ ଯାଇଥିଲେ ନା?
4 ମାସ.
4 ମାସ. ତ 11 ହେଲେ ଇଏ ହେଲା 8 ମାସ, ଗୋଟେ ମାସ 9 ମାସ ହଉଛି. 9 ମାସରୁ ଆପଣ 4 ମାସ ତ ନା 5 ମାସ ଅଧିକା ହେଲା. So it is 5 years and 5 months. 27, maybe 6 months. 5 years, 6 months ହଉଛି.
Your lordship has I ordered it 15/7/2021 and directed for consider the bail liable half of the sentence, my lord. 15/7/2021. And has no antecedents.
IA number 1597 of 2023 is an application for interim bail.
File for bail 3.
This is an application for bail under section 389 CRPC. The learned counsel for the petitioner has filed the surrender certificate, which is taken on with its memo, which is taken on record. It is submitted that after availing the interim bail period of 4 months, as per the order dated 5/12/2022. Passed in IA number 1505 of 2022. The petitioner has surrendered, and since he has undergone half of the substantive sentence, and there is no chance of early hearing of the appeal in the near future, as paper books have not been prepared. And the petitioner has not flouted the terms and conditions of the earlier interim bail order, the bail application may be favorably considered. Learned counsel for the state has produced the custody certificate dated 30/11/22 from the Superintendent Sub-Jail, Digopohandi, and on the basis of such custody certificate and the interim bail order, granted by this court on 5/12/2022. It appears that the petitioner has remained in custody for 5 years, 6 months. Considering the submission made by the land counsel for the respective parties, the period of detention of the petitioner in judicial custody, the period already undergone by the petitioner, and the fact that the petitioner has not violated the terms and conditions of the earlier interim bail order in view of the commercial quantity of ganja
Poppy straw
seized from the possession of the petitioner and bar under section 37 of the NDPS Act, while not inclining to release the petitioner on bail on merit, but I am inclined to grant him interim bail for a period of 3 months from the date of custody, from the date of release. Is this matter? In the week commencing from such and such date, you will file the surrender certificate. IA is disposed of. Yes.
Okay, 14.
May it please your lordship. And the appellant has been convicted under section 20B of NDPS Act, my lord, for a period of 10 years, my lord. Earlier, the appellant was released on interim bail and he has surrendered in time, my lord.
Which order you are granted interim bail?
27/3/23, my lord. It was the last interim bail. He has been released on bail twice, my lord. The last one on 27/3/23.
27?
3/23.
You are granted interim bail for a period of 1 month.
1 month.
On the ground of there is a wife of the petitioner is having cardiac problem, all right. So thereafter you have surrendered at right time.
My lord.
Where is the surrender certificate?
It has been filed, my lord. Ordered at 9/5/23, my lord. On 9/5/23.
9/5. 9/5/23. Okay, files the surrender certificate. Okay. So now it is another interim bail application.
No, my lord. I am pressing for the bail application.
Yes.
That's IA number 856, my lord.
So what period you have remained in custody?
3 years and 8 months, my lord.
So you stay there. 3 years your bail cannot be granted. IA number wants to stay realization of fine. IA number 856 after Durga Puja holidays. Yes.
Okay.
Yes, next.
115. 119.
Please, Your Lordship. Well, the relevant page of the judgment, my lord, page 24, and the convicted serial number 7, my lord, and sentenced to undergo arrest for 10 years and fined 10,000. And in the page 24, my lord, even a charge has been framed, and he has been acquitted 341, 296, 326, and 30 of the Arms Act, my lord, acquitted. In the last occasion, my lord, in the case, my lord, as per the evidence of the D22, in fact, victim has sustained injury by an accidental fall from 60 feet embankment, my lord. And moreover, since 2 doctors have been examined, one of the doctor has been examined on behalf of the prosecution, and another doctor has been examined on behalf of the defense, my lord, that is D22.
Have you supplied deposition copies?
My lord. And D22, the doctor said injury can
So
be...
it is 10 years sentence imposed.
My lord.
And whether you were on bail during trial?
My lord.
So how many years you have remained in custody?
Now, presently 2 years, 2 months in total, as on today.
Who is injured?
Injured, my lord, Pitbull 5. Pitbull 5 is the injured, Vishwa Prasad Mahanti. The injured. Pitbull 5. And I have given one of the date chart, my lord.
What he has stated about the assault?
Assault, my lord.
Your Lordship, I am appearing for the information.
Yes.
Okay, I will hear it. Here the appellant is one Rakesh Parida.
Rakesh Parida.
So then I proceeded to Balijhari jungle in my motorcycle with a camera. On the way near so-and-so, accused Rakesh detained me, brought out a kotari and tried to give blows by kotari aiming at my head. Knowing his intention to hit my head, I resisted the kotari blow of the accused by swinging the left hand, as a result of which I sustained bleeding injury on my left palm. When I fell down from the bike and tried to rise, the accused then gave a blow to my left hand by kotari, as a result of which left hand up to elbow was cut off and fell on the ground, being separated from my left hand. Accused gave 3 blows by kotari to the fallen portion of the hand. I raised Allah, but he glazed so-and-so, okay. So repeated blows have been given. Now who is the doctor?
My lord, doctor, the Pitbull 7, my lord.
गुड़ा इंजुरी अच्छी 9टा इंजुरी सबू 1 2 3टा इंजुरी ग्रीवियस rest are simple.
All injuries can.
And there is chopped wound also.
Yes, sir. On the incident, Your Lordship, the 7th August, Your Lordship called for that photograph also. Your direction was issued, my lord.
7/8/2023,
my lord. 7th August, my lord. The last order.
Produce the criminal antecedent, then health condition report of the injured and photographs, as it is stated at the bar that one hand of the injured has been amputed due to occurrence.
Yes, sir.
So health condition of the injured, Vishwa Prasad Mahanti. On verification, so one case has been registered against case 47 Bihar Road section. On local verification, so His health condition is now okay, and he has lost his left hand from elbow, and his right hand partially working condition for kind perusal. Photograph का तो लिख सकते हैं.
Young man with two daughters. Young man, 40 years. Old. And two daughters, surviving two daughters. And the impugned judgment page 12, the learned court below specifically directed that during the examination of PW5, court has also noticed that the left hand has sharp severe up to the left elbow and the artificial limb has been planted there.
So what is your submission?
My lord, my submission would be D22, the occurrence took place at Balijhari. But nobody was examined by the villagers of the Balijhari. But
अरे से injured कथा के कौन तो से बाली गई से.
Yes, my lord. Regarding just I mean,
how do you overcome injured evidence?
Yes, my lord. I'm coming.
The person who has sustained the injury,
My lord,
is the best person to say.
My lord.
Say,
but I want to draw your kind
why
attention.
you will leave the real culprit and entangle the
Yes, my lord.
falsely the other persons?
My lord, just
And there are other eyewitnesses as it appears.
I want to draw your kind attention. Paragraph 4 of the proceedings of the doctor, my lord, D22. In case of difference opinions by the doctors, the matter will be referred to medical board to decide the matter, and the opinion of the medical board is final. But my respectful submission would be, since it was a cross-examination that was reflected in paragraph 4 of the D22, but in paragraph 19 of the judgment, page 19 and paragraph 19. Page 19 and paragraph 19, I may be permitted place, the said portion not reflected in the judgment. Since two views are before the court below, regarding the one doctor is from prosecution, another doctor.
What opinion?
Yes, my lord. Since two opinions are there.
What are two opinion में कौन?
Opinion means, my lord, because of the T1 said it can be possible by fall over hard and projected object. 30 foot because of the eyewitness, he said D2 is the eyewitness. He said because of D2 said I saw a person. D2 is the same again. I saw a person coming by motorcycle in a high speed and dashed the motorcycle on a stack of the stones, and that person thrown away from the motorcycle and fell down on left side stone embankment, rolled down and fell by the side of the embankment. And in the cross-examination, he said the severe hands of Kanhu Mahanti, P5, was lying on the stone stack, and the Kanhu Mahanti fell down 60 feet below the embankment. 30 foot one hospital. So that this is the evidence of the eyewitness who said about this. And moreover, the another doctor they said this injury can be possible by fall over hard and projected object. And said doctor also said, since two opinions are therein, and it is the duty of the court, it will send the matter to the medical board final, but same as not reflected in the judgment of the paragraph 19 and page 19 of the judgment.
Are the learned counsel for the appellant, learned counsel for the state, and learned counsel for the informant? The learned counsel for the state has produced the written instruction received from IIC Balikuda police station, wherein it is mentioned that another criminal case, that is Balikuda PS case number 90, dated 25/8/2021, is pending against the petitioner under Section 47A of Bihar and Orissa Excise Act. It is further mentioned that the injured Vishwa Prasad Mahanti is PW5, na?
Yes,
Yes, PW5 has lost his left hand from elbow and his right hand is partially working condition. However, his health condition is now okay. The London Council for the informant also filed the photographs of the injured as per the order dated 7/8/2023. The London Council for the Subpara petitioner submitted that out of 10 years of substantive sentence imposed by the London trial court, the petitioner has already undergone sentence of 2 years and 2 months, and there is no chance of early hearing of the appeal in the near future. Balance of convenience is in his favor, and therefore the bail application may be favorably considered. Land Council for the petitioner further submitted that though the prosecution case is that the injured was examined, injured bracket PW5 was examined by the doctor bracket PW7, and he has given his opinion regarding the nature of injuries. But the defense has examined one eyewitness as DW?
DW2, my lord.
DW2, and the doctor as DW1. Say evidence kindly. No, that is PW. DW. Where is the DW statement? Huh? এটা লেখাই নি কোন यहाँ पे DW2 and the doctor as DW1.
My lord.
1. Who has stated that the injuries noticed on the person of the injured can be possible by fall over hard and projected object. Very that he was shown that medical document and asked the questions.
My lord, paragraph 4, the cross-examination in case of different opinions.
Give it that where is the material that when he was examined, he was shown the medical examination report of PW7 and put these questions that that a particular exhibit which has been marked as exhibit What is the medical examination report of
My lord, original medical examination report has not exhibited. In place of that, one xeroscopy has been exhibited. And PW will submit the doctor on behalf of the prosecution, my lord.
Okay, learned counsel for the state as well as learned counsel for the informant objected to the evidence adduced by the DW1 on the ground that there is nothing on record that he verified the medical examination report of the injured before giving his evidence. And since he has not examined the injured, his evidence has got no evidentiary value. Considering the submission made by the learned counsel for the respective parties, nature of injury sustained and by the injured and his evidence at this stage while not inclining to release the petitioner and the impact of the assault, I'm not inclined to release the petitioner on bail. Liberty is granted to the petitioner to renew the prayer for bail if after undergoing half of the substantive sentence imposed by the learned trial court, the appeal is not taken up for hearing. Yes, next. Stay realization of finding.
My lord, may kindly see the order dated 24/7/23 and the subsequent order.
24/7.
Yes.
Last chance is given till next date to comply the earlier order passed by this court regarding address verification of the appellant. So, he's an outsider or what?
Yes, my lord.
He's a man from?
My lord, he is a man from state of Bihar.
Bihar. So, Mr. Tripathi?
A letter has been sent, but no instruction received.
And have you given the surety documents?
My lord had only asked for verification. If verification
So
is
that leave it that they have not verified, risk is there.
my lord,
You just
I'll
supply
the surety.
the learned counsel for the state submitted that
Lordship may grant me 7 days time within that.
till date he is unable to get the report of address verification. Let the learned counsel for the appellant supply the names, address, and documents of two local sureties who are interested to take the petitioner on bail within a week, on receipt of which the authenticity of the documents as well as genuineness of the bailers be ascertained through the IAC of Mohana Police Station. Yes.
My lord.
Free copy of the order be handed over to the learned counsel for this.
121.
124 Mr. Asit Kumar Jena. Nadi.
No, Devasis Punda.
Devasis Punda, huh? Okay, pass over. Next.
I think 125 pass over.
Okay. Yes.
125.
One 130.
1
131 offense होला 376(3) notice ଯିବ extra copy by Monday ଦେଇ ଦିଅନ୍ତୁ ହେଲା extra copy ଏଟା ଆସିବ 9 ତାରିଖ 9/10/2023
Oblige.